All right, thanks everybody for joining today. As Karen and Melanie indicated, my name is Bob Rice. I'm Western Regional Counsel for Title Resources Guarantee Company. We are happy to be your partners across the country. I got to do a little disclaimer. My region is primarily in the western part of the country. So those of you in California and the other western states have probably dealt with me before. For those of you on the East Coast, it's very nice to meet you. I tried to include some cases in the presentation today that were from across the country, but you will notice that they are kind of heavy on the western states. But that said, they're pretty universal. What I'm discussing today is the ALTA policy forms, primarily the ALTA owner's policy in the 2006 version. In the past, when I've taught classes on the ALTA policy involving the risks, exclusions, and conditions of the title insurance policy, they have been very, very dull. Generally because it's just kind of reading the actual policy language is not a super exciting endeavor. So I've always tried and struggled with ways to make it a little more interactive. And I came up with this presentation in an attempt to do that. So what we're going to do is I'm going to cover a few of the policy provisions in the context of an actual case or lawsuit or claim that has arisen to give some context to the provision rather than just reading them. I think we're all familiar with the ALTA policy. They're exactly the same across the country. The exception is going to be those of you in states that have promulgated forms, Texas, Florida, which I believe mirror the ALTA policy, but it might be slightly different. So keep that in mind if you're in one of those states. But generally speaking, the ALTA policy has basically 5, sometimes 6 if you have endorsements, portions of the policy. They all have the covered risks, which are the items that are insured against, which you are insured for, or the problems that you are insured against. The exclusions from coverage, which is going to be boilerplate, same in every single policy. The conditions, which is kind of the terms of the title insurance policy. Those 2 are going to be the same in every single ALTA policy. And you're going to have Schedule A and Schedule B. Both the Schedule A and Schedule B are specific to the policy and the property you are insuring, and then endorsements, if any, are requested. Now with that, just a little groundwork there, we're going to just jump into our first case study. This case is called Points of Rock Ranch versus Sun Valley Title Insurance Company. I'm going to give you the facts and then go over what policy provisions were discussed in this case or were implicated in this case. So in 2001, the Frenches purchased property in Blaine County and obtained a title insurance policy from Commonwealth Land Title. In February 2002, the Frenches conveyed their property by warranty deed to Points of Rock LLC, which is wholly owned by French. And the fact that French conveyed the property to their wholly owned LLC is an important fact. This also is an important fact. The warranty deed in this case was expressly made subject to the easements of record. So there were exceptions that actually were contained in the warranty deed itself. Fast forward April 2002, the Frenches learned that the United States had an easement across their property. That U.S. easement was recorded in 1954. However, the 1954 easement was not shown as an exception on the French's 2001 title insurance policy that was issued by Commonwealth Land Title. As you can imagine, the Frenches were not too happy about this easement that it impacted their property, so they filed a claim, and the title insurer denied that claim. So the Frenches followed suit. What policy provisions are implicated? The first one is continuation of insurance. And the second one, and most importantly for this example, is going to be the definition of insured under the policy. So first, let's attack the continuation of insurance. On this slide, continuation of insurance, and this is verbatim from the policy itself. The Coverage of this policy shall continue in force as of date of policy in favor of an insured only so long as the insured retains an interest or estate in the land or holds an indebtedness secured by a purchase money mortgage given by a purchaser from the insured, or only so long as the insured shall have liability by reason of covenants of warranty made by the insured in any transfer or conveyance of the estate or interest. So what does that really mean? So putting that into plain English, what that means is continuation of coverage under the policy lasts as long as the insured retains an estate or interest in the land. That means the name insured, the Frenches, as long as they own the property, they're covered under the policy. Second, the insured holds an indebtedness secured by a purchase money mortgage given by a purchaser from the insured. So basically, the Frenches sold the property and carried back a deed of trust or mortgage. They would still be covered under the terms of their owner's policy. And third, the insured shall have liability by reason, their coverage continues if the insured shall have liability by reason of a covenant of warranty made by the insured in any transfer or conveyance of the estate or interest. So what does that mean? That means the Frenches will have coverage, continuing coverage under their policy for the deed warranties contained in the deed that they gave to a purchaser. So in this case, the Frenches conveyed to their LLC. So any deed warranties contained in that deed to their LLC, the Frenches would still have coverage under their existing policy. However, in this case, remember I indicated that the Frenches deeded the property to their wholly owned LLC. So in this case, the court held that the Frenches were not entitled to recover under the terms of their policy of title insurance where they discovered an undisclosed encumbrance after they had conveyed the real property to another person. And a lot of you who have actually read a title insurance policy are probably saying, whoa, what's going on? That should have been covered under the policy. And the fact is you're correct. Remember, this policy that the Frenches took out was issued in 1991. So they would have been using the 1992 ALTA policy form. There's a substantial revision of the ALTA policy form in 2006. And that's where the definitions come into play. The definition of insured is a defined term. It was in the 92 policy and it is in the 2006 policy. In the 92 policy, insured was defined as the insured named in Schedule A, which would have been the Frenches, and those who succeed to the interest of the named insured by operation of law, as distinguished from purchase, including but not limited to heirs, distributees, devisees, survivors, personal representatives, next of kin, or corporate or fiduciary successors. So the 92 policy did not make a provision for the Frenches transferring the title to their wholly owned LLC. So in the Points of Rock case that we just discussed, the court decided that the Frenches did not have coverage under their policy. However, under the current 2006 policy, the outcome of that case would have been much, much different. And that's because of the definition of insured in the policy is as follows: a grantee of an insured under a deed of trust delivered without payment of actual valuable consideration conveying title if the stock, shares, memberships, or other equity interests of the grantee are wholly owned by the named insured, or if the grantee wholly names the named insured. So basically, under the 2006 policy, the French's wholly owned LLC would still be considered and insured under the title policy, and there would have been coverage. So what are the takeaways? The takeaways from this case study are going to be definitions are important. Pay attention to the definitions. Probably one of the most common questions I get regarding whether somebody transfers a property to their LLC or to their trust is, are they still covered under the policy? And to make that determination, you just need to go to the policy itself and read what the definition of insured is under that policy. And the other takeaway is oftentimes we'll get asked for the additional insured endorsement. And generally speaking, since the 2006 policy form was implemented, 14 years ago, the need for the additional insured endorsement has really gone away in most circumstances. And if anybody has any questions about these, if you want to put them in the chat box, I'm more than happy to answer them as we go along, or you can save them for the end and Melanie can read them to me at that point. But until, yes.
We actually do have some questions. A couple of them pertain specifically to the case study you just went over.
Sure.
Do you want to review them now?
Sure.
Okay. Question number 1, will the easement show up in the plat map or survey on the title commitment?
It should have, but in this case, the title agent that issued the commitment and subsequently issued the policy just flat out missed that easement. And it was a recorded easement. It was recorded with the county recorder with all the rest of the real property records. It was just missed.
And another question, if the Frenches had not conveyed the title to the LLC, the coverage would have paid the claim?
Yes, it would have.
And then the last question for case study number 1, does the definition of insured change and vary from state to state?
For the most, does the definition of insured vary from state to state? For the most part, no. It could even, I shouldn't say, it doesn't vary. The definition of insured is the same on all ALTA policies.
Very good. All right, so we'll go ahead on to case study number 2.
All right, thank you very much. The second case study is out of Florida. And actually, I went on to Google Earth and looked at this one, and it doesn't look like much has changed with this property since this case came out several years ago. But in this case, it's Title and Trust Company of Florida versus Barrows. And in this case, the Barrows purchased a lot surrounded on 3 sides by land owned by others. So they had a lot surrounded on all sides by independent lots owned by other people. And all this was part of the beach subdivision. On the fourth side of the Barrows lot was a platted street called Viejo Street, which had been dedicated to the public and accepted by the county. However, the road, Viejo Road, had not yet been constructed by the county. On the opposite side of Viejo Road was a Corps of Engineers right-of-way in which there was a stone breakwater. And then on the other side of the stone breakwater was the intercoastal waterway that was just open water. The realtor who sold the lot to the Barrows told them that the county would improve Viejo Street once the Barrows began plans for building on their lot, which is a very convenient sales pitch, I might add. As of the date the policy is filed, as of the date the lawsuit was filed, there have been no improvements for Viejo Street, and the county has no present plans for making any improvements. The road, and I put that in quotation marks, which is Viejo Street, is merely just a continuation of a sandy beach. Additionally, to add injury to insult, a year after purchasing the lot, the Barrows obtained a survey which disclosed that the elevation of their lot is 1 to 3 feet above the mean high water mark. And they later discovered their lot, along with Viejo Street right-of-way, is covered by high tide water during the spring and fall of each year. So not only is the street not improved, it's also impassable during certain times of the year. So obviously the Viejos are not very happy about this. They filed a claim with their title insurer, and the insurer denied the claim. So they filed a lawsuit. One thing to think about here, of the policy, the owner's policy, covered risk number 4 on both the ALTA owner's policy and the ALTA lender's policy is the right of access. Covered risk number 4 provides title insurance company insures against loss or damage sustained by the insured by reason of no right of access to and from the land. And this is important because it's arguable whether the Viejos had access. They bordered a street, but that street wasn't improved, and that street was underwater for part of the year. So as I said, the borrowers filed suit against the title company, arguing that the Viejo Road was impassable. The title company argued, and actually in this case, the Florida Land Title Association filed an amicus brief in the case that made this argument as well. But the title company and the Florida Land Title Association argued that defects in the physical condition of the land are not covered by the policy. The title policy only assures against title defects. And the court agreed with this statement. And this statement here was with regard to the access that the Barrows had. But you're going to find this issue with the physical condition of the land being covered by a policy will also come up in a later case study that we discuss on the marketability of title. So in this case, the court held that there's no dispute that the public record showed a legal right of access to the Barrows property via the platted Viejo Street. So the policy ensured that the Barrows had access. However, the title policy only insured against record title defects and not against physical infirmities of the platted street. So basically what the court said was, yes, we're ensuring that you have access, and you do have access because there is a physically recorded, a recorded street dedication that's been accepted by the county. So that is a public road. It's just not maintained by the county. So we're not ensuring the condition of your access. We're only ensuring the fact that you do have access. And this brings up a very important point by way of endorsement. Oftentimes by lenders, especially, I get asked, what endorsements do I need? And I always tell them I don't recommend endorsements. You tell me what you want to protect against, and I'll tell you what endorsements you want. But one I always tell them that they should highly consider is the access endorsement, which is the ALTA 17-06 or the ALTA 17.1-06. These endorsements provide coverage that ensures that the land abuts a named street. In this case, it would have been Viejo Street. It provides assurance that the street is physically opened and publicly maintained, that the land has actual pedestrian and vehicular access, and that the insured has right to use existing curb cuts along the abutting street. So in this case, if the Barrows had gotten the ALTA 17 endorsement, they would have had the assurance that the street was physically open and publicly maintained. So if they would have had the ALTA 17 endorsement in this case, I think the outcome of the case would have been much, much different, and there would have been coverage under the policy. And I'll pause for a minute for any questions on the Barrows case.
It's not a question, it's just, will we get your contact information to follow up with questions on future scenarios? And the answer to that is yes, we will provide the information.
Yep. And also, you'll have my email address. And if you want this slideshow with all the this information, you can directly email me as well, and I'll be more than happy to send it to you.
Perfect.
All right, jumping to the other side of the country, we're now in Washington State. In this case, this is Dave Robbins Construction versus First American Title Insurance Company. In this case, Dave Robbins Constructions, we're going to call them DRC for short, purchased 5 lots, which they intended to develop and build single-family residences. DRC received a separate policy for each of the 5 lots. After purchasing, DRC obtained building permits and began improvements. DRC received stop work orders, which required DRC to obtain archaeological surveys because the lots were located within a historical district designation. Important fact, the historical district designation had not been recorded with the county recorder. And in Washington State, real property records are recorded with the county recorder. Obviously, DRC was not very happy that they had to pause construction. They filed a claim with First American. First American denied the claim, and DRC sued them. And the allegations DRC made against First American were that First American should have discovered the historical district designation. And I didn't mention that the historical district designation was not mentioned in DRC's commitment or policy. DRC also alleged that the historical district designation negatively impacted the title, that DRC may not have purchased the lots had it known about the designation. And this is an interesting choice of words, that DRC may not have purchased. And that actually is straight from the case itself. I found it odd that they didn't make this the assertion that they would not have purchased the lots had they known about the historical designation. And lastly, DRC sued alleging that First American committed bad faith by refusing to provide coverage. So what we have here is a guy who owns a bunch of lots, is building homes, and has to pause or alter his construction because of a historical registration designation of some type. So what does this bring up? As I mentioned earlier with the Barrows case, when the court addressed that the policy doesn't ensure physical conditions of title, it ensures legal conditions of title. And that brings us to this case. Covered risk number 3 under both the owner's and lender's policy is we insure against unmarketable title. And you have to wonder, what is unmarketable title? That argument or concern comes up quite often. An unmarketable title is actually a defined term in the policy under condition 1, subsection K. An unmarketable title is defined as title affected by an alleged or apparent matter that would permit a prospective purchaser or lessee of the title or lender on the title to be released from the obligation to purchase, lease, or lend if there's a contractual condition requiring the delivery of marketable title. I've read this definition probably 25 times, if not more, probably a lot more. And I've never understood why the ALTA chose to define unmarketable title by defining it as title that is not marketable. That is just nonsensical to me. But anyway, luckily the Washington court did give us some insight as to what Washington believes is marketable versus unmarketable title. In this case, the court stated a difference exists between economic lack of marketability, which relates to physical conditions affecting the use of the property, and title marketability, which relates to defects affecting the legally recognized rights and incidents of ownership. One can hold perfect title to land that is valueless. One can have marketable title to land while the land itself is unmarketable. So what does that mean? And I think that's a much clearer definition than what's actually in the ALTA policy itself. And I kind of always go back to under what the court said in this case is that one can hold perfect title to land that is valueless. So if there's a condition of a physical condition of the property itself that affects the value of the property, that's not really a title concern, because you can have perfect title to land that, is worth nothing. So based on that definition, so to speak, the court held that there were no defects affecting the legally recognized rights and incidents of ownership of DRC properties, and therefore title was not unmarketable. So the court did rule that DRC had marketable title to the property, and so they denied coverage on that aspect. However, DRC did raise another legal argument, and that was based on covered risk number 5. And covered risk number 5 under the 2006 owner's policy provides the violation or enforcement of any law, ordinance, permit, or government regulation, including those relating to building and zoning, restricting, regulating, prohibiting, or relating to the occupancy, use, or enjoyment of the land, the character, dimensions, or locations of any improvements erected on the land, the subdivision of the land, or any environmental protection. And so DRC argued, well, hey, the historical designation of this property affects our ability to develop the land, and that would be a law, an ordinance, or a permit of a governmental body. However, the last paragraph of covered risk number 5 says if a notice describing any part of the land is recorded in the public records. So for one of these violations or enforcement of a permit or ordinance or law is out there, that notice actually has to be recorded and describe the land that is the subject of the policy itself. So in this case, as I indicated, the notice of historical designation had not been recorded in the real property records. As I mentioned, DRC argued that the covered risk that the stop work order amounted to the enforcement of a governmental regulation, which it did. DRC further argued that the notice did not need to be recorded with the county recorder because the term public records includes all records on file with all governmental agencies. The court did not agree with that. And the reason the court did not agree with that is because the term public records is a defined term in the policy. Condition 1I, which is the definition portion of the conditions on the policy, defines public records as records established under state statutes at date of policy for the purpose of imparting constructive notice of matters relating to the real property purchasers for value and without knowledge. So basically what that says is wherever you record your deed, that's where the notice of the governmental action or permit or problem would have had to be recorded. And generally that's going to be with the county recorder's office. So again, the court denied coverage under the governmental regulation coverage in the policy. Any questions on Dave Robbins' construction case?
We do, but before we do ask those, we had a last question for case study number 2.
Okay.
Just to clarify a bit, for the Barrows, would the claim have been awarded if they had that additional coverage you were talking about, the 17.06, I believe it was?
Yes, so if the Barrows would have obtained the ALTA 17-06 endorsement, which is the access endorsement, I believe the court would have found coverage under the policy.
Thank you. With reference to case study number 3, how does title insurance work for land? Will the insurance change after a residential building is built on the land? No, is the short answer. So if you bought a bare lot, and when you bought that bare lot, you got an owner's policy, and then you hired a contractor to build you a home on that lot, you're still going to be covered under that policy. And the fact that you have a home on that policy now, or improvements on that piece of property now, are not going to make any difference in coverage. And I say that it's not an exception, but anything, let's say the exception would be, let's say you bought the lot, it was insured, then you build a home, but you built a home and that home you built encroached on an easement that was already on the property. That would not be covered by the policy because title insurance policies only provide coverage for things that have happened prior to the policy date. So that would be a post-policy issue, and that would not be covered. And it also probably would, in that case, the encroachment of the home onto the easement would also be denied based on the exclusion from coverage of suffered, assumed, or agreed to by the insured. Since you were the owner of the property, you built the home, you basically caused the claim yourself, so that would not be covered either. And the third consideration is, in that case, the amount of your policy would be probably significantly undervalued. If you buy a lot for $100,000 and you build a house for $250,000, all of a sudden you have, $350,000 wrapped up in your lot with a home on it. Your policy
limits at that point would only still, they would remain at $100,000. So in that case, you could get possibly an endorsement in some jurisdictions if it's filed or available to increase the amount of your policy if you wanted to.
All right, thank you. One more question, a little bit more general. How does a realtor or a buyer know to ask these questions? They're not referencing that endorsement specifically, but that would be a good example. How would the Barrows have known to ask for that particular endorsement?
They probably wouldn't have. You know, a lot of times, especially in residential transactions with owners' policies, very few, if any, and I'd say in probably 99% of the situations on the owner's policy, no endorsements to the policy are issued. So I don't think the realtor or the buyer did anything wrong in this case, or they were negligent for not asking for that coverage. It just kind of is what it is. Ignorance is bliss, for lack of a better term. In some parts of the country, well, I shouldn't say in some parts of the country, there is another type of owner's policy that is used commonly. The ALTA also has a policy called the ALTA homeowners policy, which has gained a lot of traction in Western states, but I don't think it's gained much traction, if any, on the eastern part of the country. And the ALTA homeowners policy covers actual vehicular and pedestrian access. So basically in the ALTA homeowners policy, the coverage of the ALTA 17 endorsement is incorporated into that policy itself. So again, if they would have had that policy, that policy being the ALTA homeowners policy, there would have been coverage. But I do not believe Florida is a promulgated form state, and I do not believe Florida has adopted the ALTA homeowners policy. So I don't think it's even available in Florida.
And Bob, this is not a question, but if I remember correctly, the commitment that the buyer receives prior to closing will cover the definitions and the exclusions and the conditions. So would you advise just a very, very close reading of the commitment so that they know what would be covered?
Yes and no. The commitment does not have the same terms and conditions that the policy itself has. However, the commitment will tell you what policy is going to be issued once the transaction closes. So if you look at your commitment, you could thereafter request, just a blank copy of the policy form that's going to be issued, and you could see that and read that.
And then we do have one more question with regard to case study 3. Okay. Can you put in simple words why case 3 was denied?
Case 3 was denied because the historical register designation of that property was not recorded in the public records.
Thank you. And I think we should have time for another case study.
Okay, and I'm gonna choose. I'm not gonna go in order now.
While Bob is selecting the last case study, I did want to let everybody know that I have put his email address in the Q&A box. I know several of you were asking for a copy of this information later.
All right, let's go with this one. This is Bull versus Stewart Title Guarantee Company. And I like this one because it discusses how a Schedule B exception was drafted, and it points out why you should be careful in drafting your exceptions. So in this case, the Bulls purchased a home in 1993 in Maple Ridge Estates subdivision. Maple Ridge Estates subdivision is a platted subdivision of just single-family homes, so pretty cookie-cutter, ordinary, everyday deal transaction. The Bulls were aware of the existence of an underground ditch that crossed their property. So in this case, the Bulls, at the back of their property, back of their lot, there was an underground ditch that had been buried. And there was an exception on the Bulls policy for that underground ditch. Fast forward 4 years, in 1997, the U.S. Bureau of Reclamation performed a survey in Maple Ridge Estate subdivision. As a result of this survey, the Bureau sent a letter to the Bulls and some of their neighbors informing them that in 1910, so 87 years prior, the U.S. was the grantee of a fee simple strip to a fee simple title to a 30-foot strip of land through the Bulls' property and other parts of property within that subdivision. So basically in 1910, the U.S. got fee simple title to this 30-foot strip wide piece of property that went right through the middle of this subdivision that was created, 90 years later. And this is common in arid states. People in Florida and in the East Coast, you probably don't have a lot of water and ditch issues, but in the West, in arid climates, the Bureau of Reclamation has lots of easements and rights of way and different ownership scenarios for canals that will transfer water from a reservoir to an arid area so they can farm or for domestic purposes or whatever. And this 30-foot right-of-way or fee simple title to this 30-foot strip was probably part of one of these canal systems that was designed in the early 1900s. The letter that the U.S. Bureau of Reclamation sent to everybody went on to advise everyone that the developer had relocated the ditch to its present location, and the present location of the ditch, the buried ditch which the Bulls knew about, was not entirely within that 30-foot fee strip. So basically the developer said, hey, I have this ditch going through the middle of my property. I'm just going to go ahead and move it to the borders and bury it so nobody will care. And the ironic thing about this, and this wasn't in the case, but I'm sure this happened, my guess is that developer got permission from the U.S. Bureau of Reclamation to move that ditch. So the fact that the U.S. Bureau of Reclamation came back later and said, hey, wait a minute, we have a problem, I think is a little disingenuous, but oh well, it is what it is. Moving on, the deed in the fee strip was not an exception on the Bulls' property. However, there was a Schedule B exception for the existence of an underground ditch, and that's an important distinction. So the fee strip that the U.S. was deeded back in 1910 was not an exception on the policy. The Bulls filed a claim asking that Stewart pay the remaining balance on their mortgage. Stewart denied coverage on the basis that the claim was accepted from coverage. So there, Stewart said the exception from coverage was the fact that a Schedule B exception accepted the buried ditch from coverage. Stewart also asserted that there's no diminution in value, that the Bulls failed to provide a proof of loss, and laid in the Stewart offered them $2,500 to settle as a nuisance settlement. So what policy provisions are implicated? We have proof of loss, which is condition number 4. We had covered risk number 1. Schedule A, paragraph 2, which is the state or interest, is discussed. The Schedule B exception is discussed. So let's start with covered risk number 1. Cover risk number 1 is title to the estate or interest described in Schedule A, and Schedule A is where you have a description of your property, your legal description, being vested other than as stated herein. Schedule A, paragraph 2, the estate or interest in the land described herein in which is covered by this policy is fee simple. So in the Bulls policy, they were ensured that they had fee simple title to the entire lot, not just a portion of it. And Schedule A, as I said, went on to describe the land as the entire lot. the Schedule B Part 1 exception, and this is the exception that the title agency wrote in. Any question or issue which may arise or claim of loss which may result from the existence of an underground ditch which does not appear to affect improvements situated upon the land. So that's the exception that the title company put in for the ditch that had been buried. So what the court found that exception 11 was ambiguous, and exception 11 was the Schedule B exception that the title agency put down, and that was the exception that excluded from coverage the buried ditch. So the court said, hey, exception 11 is a little confusing, but then the court said, hey, wait a minute, even though it is a little confusing and ambiguous, it doesn't really matter because the Bulls' claim did not arise from the existence of the ditch, but the existence of the ditch to the fee strip that Stewart missed, so that the existence of exception 11 was immaterial. So what the court said is, it doesn't really matter that you had that exception on there because there was a whole 30-foot strip of land within the Bulls' lot and block that they didn't own, and you insured them that they owned the whole thing. So the court found that there was coverage under the policy because there was not an exception on the policy for the fee title to the U.S. government in that 30-foot strip of land. And then the other issue, so the court found coverage. Stewart went on to make another interesting argument that the Bulls did not provide an adequate proof of loss. The ALTA policy form requires that if an insured wants to make a claim under the policy, that they must provide a proof of loss to the title insurer. That proof of loss is condition number 4 on the policy. And it states that in the event the company is unable to determine the amount of loss or damage, the company may, at its option, requires a condition of payment that the insured claimant furnish a signed proof of loss. The proof of loss must describe the defect, lien, encumbrance, or other matter insured against by this policy that constitutes the basis of loss or damage and shall state, to the extent possible, the basis of calculating the amount of loss or damage. So this kind of sounds a little ominous, but it's not as bad as you think, at least in some states that have defined what it requires. So going back to the facts of this case, the Bulls reported their claim to Stewart in 1997, immediately after they received a letter from the U.S. Bureau of Reclamation. When Stewart received that claim notice, they investigated the claim and hired an appraiser. After that, the Bulls also sent another letter to Stewart outlining the facts of their claim, including the loss of intrinsic value of the land to them and their future ability to sell the land because they don't own 30 feet in the middle of their property. Stewart, nonetheless, just offered $2,500 to settle the claim. And as I said earlier, based on that, Stewart offered that based on the fact that they said, the Bulls didn't provide us an adequate proof of loss. The court said, whoa, Stewart, you are asking for way too much. And here's what the court said when they discussed the proof of loss requirement in the policy. The amount of information provided should be proportional to the amount reasonably available to the insured. If the information is provided is insufficient to give the insurer an opportunity to investigate and determine its liability, the insurer may deny coverage. Otherwise, the insurer must investigate and/or determine its rights and liabilities. The documentation is the proof. The explanation or physical and/or financial injury is the loss. Loss must be distinguished from liability. The insurer will determine its liability with the knowledge that it must be fair and accurate or suffer the consequences. So what the court basically said was the fact that the Bulls notified Stewart that they had this strip of land that they didn't own that went through the middle of their property, that was sufficient as proof. And any loss that the Bulls asserted, meaning, the intrinsic value of the property, their ability to get full resale value when they go to sell the property later, that was an adequate description of loss. And it was up to Stewart at that point to determine, what Stewart's liability was based on the Bulls' proof and their statement of loss as well. So what I take away from this is make sure your Schedule B exceptions are always clear and concise. Even if, in this case, I didn't even think for the buried ditch itself that the exception was super clear. So anytime you're creating an exception, if you don't have one, you can automatically populate. Make sure it's very clear, basic, and to the point. And also, the proof of loss for a insured is a very low standard. Basically, you just need to provide written notice, and then you need to provide a brief statement of facts and the prospective loss. So it's not onerous at all. All policies have in them a statement of how insured will provide notice of a claim to the insured. Most all insurers allow claims now to be filed via email. They have email addresses in there. And really all the insured needs to do is say, hey, I received a letter from my neighbor. They're saying my fence encroaches onto his property and I have to replace it now. To me, that would be a sufficient proof of loss statement. So it doesn't take much. So it's not real onerous for the insured, which in my mind is a good thing. And at that point, it's up to the insurer, it's up to the insurer to make a determination if it's covered, and if so, what the damages would be. And that's all the time I have. And I'll take any questions you may have about any of these cases or any general underwriting question you'd want to ask.
Well, I think so far everybody is just happy that the homeowner won this time. So we don't have any new questions just yet. Kara, did you want to give us a brief update again as to our upcoming classes? And that'll give us, the audience, a minute to put in any last questions.
Yeah, absolutely. Thank you, everybody, again for coming. Hopefully, Bob helped you walk away with a little bit more title knowledge. And as he said, his email is in the chat. We'll also follow up with all of you with that email address. And if you have any additional questions, need any additional guidance, or want a copy of his slides, which have a lot of great information in them, then just go ahead and feel free to reach out. We do have dot loop, zip forms, negotiating classes coming up. Go over to trgc.com/virtual training to sign up for those. And then the best part is we're actually starting to finalize our fall sessions. So we're going to be doing great classes around testimonials and reviews. We're going to be doing some title scary horror stories to celebrate Halloween. So we got a really exciting offerings coming up. Again, trgc.com/virtual training. It's a mouthful, but I promise it's easier to type into your browser. But anything else, Melanie? Are we good?
No, we do actually have one more question for Bob.
All right.
Can you please briefly explain the advantages and disadvantages between the 2006 and the 2013 Alta title policies?
Oh, that was a side, Bob. Are you tired? It's a Friday.
I don't think there's any substantial differences, and I have never sat down and compared them side by side. You need to remember that the 2013 version of the ALTA owner's policy is just going to be a slight rewording of the 2006 version, so there's really no substantive differences between the 2006 and the 2013 version. However, I wonder if the person who asked that question is asking about an updated version of the ALTA homeowners policy, which was changed a bit more, I think, in 2012 or 2013. So there were a few changes to that. So I'm a little unclear about which policy form we're talking about, but really the 2006 policy, there's been tweaks over the years, but that policy form has pretty much been rock solid since it came out in 2006. Now, that said, I actually have seen them, but I didn't put it to memory because they're substantial. The ALTA is working on very substantial revisions to the ALTA owners and ALTA lenders policy that is still not. I've seen the drafts, but they haven't even come out for comments from the industry yet. So probably, I'd say in the next 2 to 4 years, we might see a large revamp of the ALTA owners and lenders policies.
Thank you. I'm going to combine these two questions because they are very similar. Should we suggest all buyers read the definitions within a policy, and what questions would you advise buyers to ask?
Absolutely, you should. Whether they actually will, I don't think so. I think the questions that they ask shouldn't be policy related, mainly because the policy kind of is what it is. I think buyers would be much better off if they showed, well, one, buyers don't really understand what a title insurance policy is in probably 90% of the cases. So you're kind of beating your head against the wall trying to do this anyway. But really, I think what would be the most beneficial for a buyer to do is if the real estate agent actually sat down and went through the commitment with them so they are aware of, what exceptions are on the policy. And likewise, if the title agency has an exception on there that's kind of general in nature that says, like CC&Rs of record or an easement, recorded as instrument number, blah, blah, blah. I think it's important that the purchaser get a copy of those CC&Rs. I think it's important that the purchaser get a copy of that easement and understand how that easement impacts their property. I mean, because if the easement, is for a pipeline on the back 30 feet of the property, yes, they own the property, but that easement probably says, hey, you can't build any structures on there. So if the person who's buying is planning on putting, a shed or a carport or a garage, behind their house in this open area, they might not be able to do that. And I think rather than buyers focusing on the policy terms, I think if they focus on, the issues and encumbrances that may affect the property more, I think that's where a lot of these problems could be prevented.
Thank you, Bob. We do have two questions specific to case study number 5, and then I think that will be it for today. Did the title company have to pay the balance of their mortgage? In other words, what was the ultimate award in case study number 5?
That's the bane of my existence when you read these reported cases. They don't always tell you what happened. So they said the Bulls won, and then the case was remanded back to the trial court to determine the Bulls' damages. So the case didn't get into what the Bulls were awarded, and that went back to a lower court. So my guess is they came in somewhere between $2,500 and the amount of money the Bulls owed on their mortgage. But I have no idea what the ultimate resolution was.
All right. And then still as to case number 5, how would we be able to find any previous U.S. ownership of part of a subject property? In other words, how should they have found that strip of land that was deeded?
Well, it was recorded in the public records. So the title agency that did the search and issued the policy should have caught it. I think the problem here arose that whoever did, well, one of two things. Whoever did the plat either missed it and didn't put it on there. And then everybody that searched from that point forward only went back to the recorded plat and forward, so they didn't go back to 1910, so they never caught it. And the other thing I kind of wonder if happened, and this is why I say, I kind of wonder about the trustworthiness of the U.S. government quite often. But in this case, my guess is the developer, before he developed this property, went to the agency, the U.S. government agency that was maintaining that ditch and said, hey, can I move it? And they said, sure. And so he rerouted that ditch around the outskirts of the subdivision. And by doing so, there may have been some thought that, the U.S. Bureau of Reclamation had an easement, and their easement was moved. and everything was fine. So I think it's probably just a multitude of errors and possibly misrepresentations that caused that, fee strip to be missed. So it's either an error when the plat was done, or there was a misrepresentation as to what the effect of moving that ditch was.
All right. And then the very last question, because I think this is a perfect wrap up to our class today. Who is paying these legal expenses of cases going back and forth in the court?
The title insurer.
Exactly. And that is the beauty of having the title insurance.
Yeah. So all these cases, even, and I had some other cases, even if, we defend our insured and it turns out our insured's in the wrong, we're still on the hook for those legal fees, and we cannot go after the insured for them. So yeah, all these litigated cases, if there's an insured, the title insurer is paying those legal fees and costs.
All right, thank you very much, Bob. And with that, I'm going to thank our audience for joining us today. I do know several of you have put your information into the Q&A box that you would like to get a copy of this, so I'll make sure that Bob gets that information. And then you do, of course, have Bob's email address directly. So with that, thank you all, and we will see you next time.
Thanks, everyone. Appreciate your time.